Good evening. What I propose to do is to first very quickly answer some of the questions which generally come to mind when we talk of Uniform Civil Code, and then go a little deeper into the issues on which we rarely have any in-depth, informed discussion in the media, particularly electronic media. So I have framed some 7-8 questions. Through these questions, my purpose is that I bring to you to the heart of the whole debate. So, Article 44 of the Indian Constitution talks of Uniform Civil Code. How do we compare this directive principle and its language with other directive principles? Because there are people who say that you have a number of articles starting from Article 37 to Article 51. You have about as many as 19 directive principles. Why courts in particular are too much worried about Article 41? And as you know that the language of Article 41 is that a state shall endeavor to secure for all its citizens uniform civil code throughout the territory of India. So, as you compare the terminology of the Constitution under 44 with other articles, I told you in 44 the words are state shall endeavor, and endeavor means attempt, aim, seek, strive. If you look at other articles of directive principles, and in a minute I will tell you what is the relationship between directive principles and fundamental rights. The expression used is like this: in particular strive, state in particular strive, or shall take steps, or shall promote with special care, or shall in particular direct its policy, or shall regard its primary duty, or shall be the obligation of the state. Now all these expressions, in my humble view, they are far more greater in terms of the directive, if at all there is a directive in directive principles, to the state. And word endeavor under Article 44 is of a less rigor. Then in some places, you know, the state shall endeavor by suitable legislation. This is about prohibition, and I will come to you about prohibition because yesterday we got two major decisions from the Supreme Court. One prohibiting sale of liquor on national and state highways within 500 meters or so. Another about upholding of the sacking of an Indian Air Force officer who wanted to have, sported a beard. And of course, my grievance is not with the law. I believe that such laws are possible, and there is much greater need in armed forces to have discipline. But in matters like this, while I am in agreement with the final outcome of the judgment, I believe the reasoning in many cases is flawed, including the Haji Ali case, on which I have written that there was no need for the court to look at the question whether Islam permits women's visiting of grave or not. We could have easily decided the case under Article 15 saying that a state shall not discriminate only on grounds of religion, race, caste, place of birth. There was no need to make any religious inquiry. So when word endeavor comes, there is more which Constitution says by a suitable legislation, which in Article 44 the Constitution has not said. And I'll tell you why it has not said. What kind of debates we had in the Constituent Assembly in enacting and drafting Article 44 when I come to my main lecture. What is the meaning of a state? A state shall endeavor. So who is a state? Now the meaning of the state in Part 4 of the Constitution, Article 37, which defines, which talks of directive principles, they say is the same which you have in Part 3 of the Constitution, which deals with fundamental rights. And their state is defined under Article 12, and it includes Parliament and the Government of India. It also includes state legislative assemblies and the government of the states, any authority established by the Government of India. It may include even authorities outside India if they are under the control of the Government of India. And if you look at the judicial decisions on this, it may include even a multinational corporation. And it may definitely include corporations on which the Government of India exercises what the court has said, deep and pervasive control. So ONGC or Indian Oil or Air India, they are also state. So the point I want to raise is, can a state government or a municipality, so Hyderabad Municipal Corporation is a state, can it make a uniform civil code which will be applicable throughout the territory of India? Because the word used in Article 44 is state. So local authorities or state authorities cannot make a uniform civil code. And when the question of uniform civil code is coming, it is only Parliament which can make a law for the entire country, for throughout the territory of India. And I need to tell you in one of the questions, personal laws are not under the exclusive jurisdiction of Parliament. Had the intention of the framers of the Constitution been to have just one law in the country, the matter of personal law would have been easily included in the union list. If it is in union list, then no one else, no state authority can legislate, no local authority can legislate. It is only the Parliament which will legislate. The mere fact that the framers of the Constitution included uniform this personal laws under the concurrent list, that means you will have a diversity. There can be a state law and there can be a union law and there can be one law in Telangana and another law in Andhra Pradesh on marriage and on divorce, on adoption, on inheritance. The other question which I have put is, what is the meaning of civil? A uniform civil code. What is the meaning of civil? And civil, you know, will mean that we are talking of what in law we call right in personam. So we make a distinction in law between right and rem, which are available against the word at large. So if you have right to equality, or your right to free speech, or right to freedom of religion, these are available against word at large. But if there is a dispute between two individuals, if it is a divorce petition, if it is a matter of custody of the child, this is a violation of right in personam, which is in the legal hierarchy will come little lower if you make a distinction between private law and public law. So they are talking of civil code, which means we are talking of contract, we are talking of sale, we are talking of properties. What is the meaning of code? Many of us think code means one law. Code may not mean one law. Already we say Hindu Code Bill, but there is not one law. You have one Hindu Marriage Act, you have one Hindu Adoption and Guardianship Act, you have one Hindu Succession Act. So there can be more than one law. Code does not mean just you need to have one law. Indian Penal Code you have, but Indian Penal Code is not the only law on criminal law. There are any number of other laws. So food adulteration law is a criminal statute. FEMA is a criminal statute. Prevention of Corruption Act is a criminal statute. There are hundreds. In fact, we are presently working on the criminal statutes of last 25 years because we want to see that in last 25 years how classical principles of criminal law are being violated in the new enactments. And we found that in last 25 years there have been around 250 such statutes. So within Indian Penal Code is one, but criminal law will have many laws. Similarly, the Indian Contract Act. Now, Indian Contract Act is not a complete code on law of contract. It does not cover partnership, which is a contract. There is another act, Partnership Act. It does not cover sale and purchase of movable properties, TV or mobile. You have a sale of goods act. It does not cover sale and purchase of immovable properties. So you have a transfer of property act. It does not deal with the incorporation of companies. So you have a Companies Act. So code does not mean just one act. It may have more than one act. That brings me to the question, what is the difference between fundamental rights and the directive principles? Because the entire debate on Uniform Civil Code, as I will show you in few minutes, is on the one hand you have a directive principles which says that its state shall have shall need to make endeavor to have a uniform civil code. On the other, people have freedom of religion and people have right to culture. So how do you, between one's fundamental right and directive principles, which one will prevail? My mind right now, RSS MG Vaidya had written a piece in Indian Express. Of course, I wrote a rejoinder saying those who do not accept the Uniform Civil Code, the minorities and the tribals, because there are tribals who have already gone in the current case in the Supreme Court. They say we don't want any one law or reforms in our laws, and within the tribes there are sub-tribes and each tribe has a different law. And there are hundreds of tribes. So MV Vaidya, the RSS ideologue, has said those who do not accept Uniform Civil Code are to be denied right to vote in Parliament and state assemblies. And I have written now the cat is out of bag. In fact, basically this is what they want, that the minorities should not have a right to. But this kind of relationship between rights and directive principles and rights and fundamental duties is not known to Indian Constitution. Rights and duties are not correlative. In the classical British formulation, as someone will put it, there is no father without a son and no wife without a husband and no daughter without a father. Similarly, there is no right without a duty or no duty without a right. They are all correlative. Is not known to us. And the Indian Constitution also does not believe with classical Hindu, Shastric or ancient Indian idea that the only right you have is to do your duty. Of course, Leon Dugai also talks in the similar terminology. So one can have all the rights without doing any duty. And even a dictator like Indira Gandhi, when she inserted fundamental duties during emergency, when the parliament was absolutely under her control, could not make fundamental duties justiciable. So fundamental duties she could not insert in the fundamental rights chapter. They were inserted in the directive principles as 4A. Similarly, there is a distinction between fundamental rights and the directive principles. Fundamental rights are the irreducible minimum which a state must guarantee to its citizens. Below it, it cannot go. These are the rights which have always been there. Therefore, in 1905, when Bal Gangadhar Tilak said, Swaraj is my birthright, there was no constitution. From where he got right to self-determination? Because these are all natural rights. Every human being takes birth with these rights. These rights are not conferred that a state can withdraw them. These rights are not some privileges which a state can withdraw. Whether you have constitution, you don't have constitution, I have those rights. They are justiciable and they are so important that if you violate my right, I can directly go to the Supreme Court of India straight away. I will not go to any other court. I can directly go to the Supreme Court. On the other hand, directive principles are just some principles, as the word will indicate, principles. These are vague concepts for which we say that government, while formulating policies, need to keep them in mind. When they are making policies, they must consider them, they must treat them as fundamental. Fundamental rights are largely individualistic rights. They are civil and political rights. Directive principles are socio-economic rights. They are second generation rights, if you want to borrow the human rights terminology. There is simply no doubt that between the two, the fundamental rights need to prevail. Of course, there have been some amendments. Article 31C was there. What happens to the authoritarian regimes? The regimes which do not believe in liberal rights, they attach more importance to duties. That's why in socialist constitutions you have idea of duties. Liberal democratic constitutions do not contain fundamental duties. We did not contain them. They came in 76. Because we want to assume power, therefore we say we want to do it in the name of directive principles, in the name of fundamental duties. Therefore, Indira ji amended the constitution, inserted Article 31C and said that if any law is made with the declaration that it is to give effect to any directive principle, the 42nd Amendment I am talking, and that impinges on fundamental rights of Article 19, you have as many as 6 rights there, or right to equality, which includes right against arbitrariness, then you cannot challenge it, because directive principles are very important. They will ensure economic and social democracy in India. You may recall Gandhiji has said directive principles are the dustbin of the constitution. Whatever you could not fit anywhere, you just put it in the directive principle. But the last line of this amendment is very interesting. Even if that law does not implement that directive principle. So you have taken away my fundamental right in the name of implementing directive principle. You do not implement directive principle, still I cannot challenge it. And it was this portion which was struck down by the Supreme Court in the Minerva Mill case, from which I am reading this extract, 1980 decision. To destroy the guarantees given by fundamental rights in order purportedly to achieve the goals of directive principles is plainly to subvert the constitution by destroying its basic structure. In the name of uniform civil code, you cannot take away right to religion or right to culture of people, because fundamental rights are superior to directive principles. Of course, the court said that they are to be harmoniously constructed. As to the relationship, more particularly about what is the relationship between freedom of religion and Uniform Civil Code, most people, including the Personal Law Board, they have always constructed their argument largely in the name of freedom of religion. And they say that personal law is part of freedom of religion. I'll give you more details as I start my lecture. This is a just quick question answer thing I'm doing. Now the other argument is, the counter argument. Well, freedom of religion is subject to public order, health, morality and other fundamental rights. These are the opening words of Article 25. So if your freedom of religion comes in conflict with my right to equality, your freedom of religion has to make way for right to equality. Because right to equality is superior to freedom of religion under 25. And under 25, you have freedom to profess and practice and propagate your religion. So if in the process of professing, practicing, propagating any other fundamental rights you contradict, your freedom of religion will be restricted. But then there is another fundamental right, which is in Article 26, which somewhat has been ignored in this debate completely by the TV channel anchors who had quite a debate, in last 2 months. This is a right which is given to every religious denomination or any sect thereof or any section thereof. So there is a freedom for me to be a Muslim, and there is additional freedom for me to adopt a jurisprudence of my choice. I can be Hanafi or Shafi'i or Maliki or Hanbali or Ahle Hadith or whatever. So every religious denomination and any section thereof will have autonomy which is greater than the autonomy given to individual under Article 25, because here it is a right of a group. We are talking of religious denomination, group, not you are not talking of one individual. It says in matters of religion, they will have freedom. This freedom is subject to public order, health and morality, but it is not subject to other fundamental rights. So in matters of religion, if my religion contradicts some fundamental right under Article 26, then religion need not make way for right to equality. If it is a violation of 25, freedom of religion of an individual needs to make way for the other fundamental right. But if it is a right of a group, of a denomination, or any sect thereof, then word and other provisions of this part is missing. This other provisions of this part occurs only in Article 25, in no other fundamental right it is there. The question of personal law, is it a question of matters in religion? And if it is so, it is not subject to right to equality. And therefore it gives greater leeway to the minorities to follow their personal laws. We'll discuss a little bit more details once I start. Similarly, what about protection of customary law in Northeast? It is constitutionally protected for Nagas and for other people in Meghalaya and Mizoram. There is, we have not even extended our criminal law to them. What to say of civil law? And that's why some of these tribes have come to the Supreme Court against interference of their laws. In the process of implementing Uniform Civil Code, we cannot violate an express provision of the Constitution giving protection to the tribal law. I have already told you who can legislate in personal law, so I'll skip that question. Then this question has been raised, oh, Muslim law has been reformed in number of Muslim countries. Why Indian Muslims are so conservative and orthodox, they don't want to accept any reform. The answer lies in minority side. There they were a majority. It is always easy to amend the law and bring a change in the law of the majority. It is always difficult to bring a change in the law of a minority. And even in these countries, even though state was the main driver of change, but in each of these states, the change was based on some juristic opinion. They took the opinion of some liberal jurist or relied on the opinion of some liberal jurist, because I am going to tell you that Islamic law is jurist-given law. It is not the law which has been made by any state, and it cannot be completely said to be even the divine law, because the divine content, as I have written in some of my articles, is less, and there is a greater human element, and human element I mean that it is an opinion of jurists. Now, that brings me to the question, when we passed the Hindu Code Bill, who were the people who opposed it and what were their arguments? Because I see a lot of similarity in what people who opposed Hindu Code Bill said and what Muslim Personal Law Board and other conservatives or fundamentalists from the Muslim community are saying. The arguments of liberals and arguments of conservatives will always be same. So, this whole thing started in 1941 when under B.N. Rao a Hindu Law Codification Committee was formed, and there was a lot of opposition. There were many people who said that codification will be an unnecessary interference with the time-tested Hindu customs, caste system, and traditional relations between sexes. In 1948, even Rajendra Prasad, who was the president of the Constituent Assembly, warned Nehru that to introduce basic changes in personal law was to impose progressive ideas of a microscopic minority on the Hindu community as a whole. The liberals were in a microscopic minority in the majority community there. The liberals may be in a minority community now in minority. Who are the others who opposed? These names are important, because let us not blame just RSS. Leading Congress leaders were also in opposition. Sardar Vallabhbhai Patel, the Deputy Prime Minister. Pattabhi Sitaramaiah, Congress President. Anand Sainam Iyengar, Speaker of the Constituent Assembly. They all opposed reforms in Hindu law. People like Madan Mohan Malviya and Kailash Nath Karju. And when the debate took place in December 1949, 23 out of 29 speakers who participated in the debate opposed Hindu Code Bill. Because of this opposition, it could not be passed in one go. Because of this opposition, Ambedkar had to resign. Because of this opposition, they used to say that Ambedkar is taking a revenge from the high caste Hindus because he is a low caste Shudra. Hindu Code Bill was said to be the atom bomb which Nehru, is going to explode on the Hindu community. So we need to understand that the kind of response you get to any reform initiative will be like this. On 15 September 1951, Rajendra Prasad even threatened to use his power to return the bill. You pass it, because Nehru was insisting. as an agnostic, Nehru was all for reforms. Of course, not with the speed with which Ambedkar wanted, because he was pragmatic. He said, I may use my power to return the bill. And you know, under the Indian Constitution, a president may never sign a bill. He may use the pocket veto, and you can't do much about it. If he returns, then you may pass it and send it again, then he is bound to sign it. If he does not return, just sleep over it, as Zell Singh slept over the postal bill, we couldn't do anything. In 1949 itself, Hindu Right formed All India Anti-Hindu Code Bill Committee, which had the blessings of Shankaracharya of Dwaraka. What were their grounds? RSS was leading the opposition to Hindu Code Bill. It organized in 1 year as many as 73 public meetings in Delhi itself against the Hindu Code Bill. Swami Karpati Raj Maharaj was given the leadership. The argument was very interesting that Ambedkar is deliberately destroying Hindu religion, and a low caste should have no business with something which is the exclusive domain of Brahmins. Swamiji also justified unregulated polygamy. You know, by that time polygamy was permitted to Hindus as well. And freely quoted Yagnavalakya. And this is how it went. If the wife is habitual drunkard, a confirmed invalid, a cunning, a barren, or a spendthrift woman, if she is bitter-tongued, if she has got only daughters and so no son, if she hates her husband, then the husband can marry a second wife even while the first is living. And he challenged Nehru and others to come and debate with him that all these are essential aspects of Hindu religion. Gita Press, Kalyan magazine published number of articles against the Hindu Code Bill and argued that only Pandits and scholars of Shastras had the right to interpret and point out rights and wrongs of Hindu marriage. These articles favored polygamy and opposed daughters' right to inheritance. It also questioned Constituent Assembly's right to legislate on religious matters. And it asked Nehru to sack Ambedkar. Then on Guru Govalkar's persuasion, I will give you an interview on Uniform Civil Code. In a minute I am going to read from greatest RSS ideologue. One Prabhuddha Brahmachari, member of this anti-Hindu code committee, was asked to contest against Nehru in 1952 when first parliamentary election took place. He was supported by Hindu Right. He did not make any speeches, but some pamphlets he used to distribute wherever he used to go against the Hindu Code Bill. And he got some 55,000 votes. But Nehru won, and after general elections, the rest is history, that Hindu Code Bill was passed. Therefore, let us be not very surprised on what the extreme Muslim right or Muslim fundamentalist or the personal law board may say against any reform in Muslim law. Now, two quotations I would like to read as I start my talk this evening. One is what Nehru has written in Young India on 15th May 1930, and this is what he said. The history of India and many of the countries of Europe, you know that we had number of wars in Europe on the minority rights, including the world wars. That's why Nehru is saying. The history of India and of many of the countries of Europe has demonstrated that there can be no stable equilibrium in any country so long as an attempt is made to crush a minority or force it to conform to the ways of the majority. There is no surer method of rousing the resentment of the minority and keeping it apart from the rest of the nation than to make it feel that it has not got the freedom to stick to its own ways. It matters little whether logic is on its side or whether its own particular brand of culture is worthwhile or not. Whether triple divorce is right or not, that is not the question. Whether Muslim personal law is progressive or regressive is not the question. The mere fact of losing it makes it real. And that is my anxiety. Are we strengthening the hands of fundamentalists in the process of this entire debate on uniform civil code? Did we not experience the same thing post-Shah Banu? Are we going to the same track again? The mere fact of losing Muslim personal law makes it real. I don't know how many of you are aware, but Duncan Derrick is the greatest authority on Indian family law. Of course, largely Hindu law. In fact, both the greatest Hindu law scholar, Werner Mensky, whom I am going to quote a little later. So Derrick said, the best way to reform Mohammedan law is not to reform it at all. This is not some ordinary man. Someone who has spent a lifetime on Hindu law, who has been writing on family law in India. And we should be ashamed that we need to study from Duncan Derrick Hindu law, because he knew Sanskrit. Mensky also knows Sanskrit. Almost all Hindu law teachers I know in law schools don't know Sanskrit, as all Muslim law teachers don't know even Persian or Arabic or Urdu. So they never really read the original sources. So Derrick says the best way to reform Mohammedan law is not to reform it at all. Let its inconvenient and archaic features wither away. Once it is accepted that this is the policy, that you are not going to interfere with Muslim personal law. That is what he is saying. Once it is accepted that this is the policy, it will wither away fast enough. If there is a frontal attack, as is happening today on electronic media, with Arnab Goswami shouting at the top of his voice, one nation, one law. If there is a frontal attack on personal law, it will survive with a tenacity it has been unable to show in countries where the majority of population are and always have been Muslims. So in Muslim countries, reforms are possible. But in India, if you try to reform it, if you criticize it all the time, if you want to show them in bad light, it will come back. They will try to protect it. I clearly remember, and Shirwani Sahib must have stopped at this bus stand, as we go from Aligarh to Muradabad, bus stops at Barbarala. There is a place called Barbarala where you have some small eatery. So it was 1986, post Shah Banu and all this, Shah Banu will tell you how Supreme Court reminded government that why Article 44 is dead letter. I believe such kind of statements do more damage than any good to the Uniform Civil Code. So on this roadside eatery, one person was reading a Urdu akhbar, Inqilab or something. And there he was saying, अगर यक्सा सिविल कोड बनी तो मुसलमानों को भी दफन नहीं करने दिया जाएगा, उनको भी जलाया जाएगा, जैसे कि हिंदुओं को जलाया जाता है, क्रिमेशन किया जाता है. If the uniform civil code is enacted, then Muslims will not be allowed to bury their dead and they will be forced to burn them just like Hindus. I was shocked. But that is the level of ignorance we have about uniform civil code. Now, in my humble opinion, a close scrutiny of ever continuing debate on the family laws in India would reveal an utter confusion of the scheme of values, right from the Constituent Assembly debates on Article 44, directing the state to endeavor to secure a uniform civil code for all citizens of India, to the Supreme Court judgments on Shah Bano and John Welletham and Sarla Mudgal, and all that happened in its way. As I told you, post Shah Bano, the fundamentalist forces got a lot of strength. It would appear that the major source of confusion is the obsessive insistence on uniformity as against social justice and women's rights. I need to tell you this evening that the three major champions of uniform civil code in the Constituent Assembly, of course it was largely the initiative of Masani, Ambedkar, Munshi and Alladi, they all sought uniform civil code in terms of national unity and not in terms of gender justice. If you look at the debates in the Constituent Assembly, they said if we get one law, we will achieve national unity. Supreme Court also said in Shah Bano, national unity. The legitimacy of the case for reform, for uniform family laws driving from a monolithic view of nation state will not only with not only a single polity but also a single culture, in my opinion, is questionable. It undermines, rather repudiates the pluralist model of liberal democratic state where cultural autonomy is ensured to all religious, ethnic and other groups of people constituting the Indian society. Its assumption of uniformity of family laws as a sine qua non of nationhood can also be questioned empirically from the example of United States, where multiplicity of family laws, each state has a different law. Not only the civil law, even criminal law is different. Some states have death penalty, other states don't have death penalty. There are things which are prohibited as crimes in some states, they are not crimes in another state. Yet this diversity in America did not come in way of cohesiveness of the state as a political nation. Reacting to the almost unanimously orchestrated opinion of the Hindus for a uniform civil code, driving from spurious concerns about the Muslim separatism and appeasement and about polygamy, causing an alarming rate of growth of Muslim population, which is of course not made out by facts. The Muslims have been equally obsessed. This is the problem. Muslims have been equally obsessed with the idea of their religio-cultural identity as if the body of laws improvised and enacted from time to time during the British period are the centerpiece of their identity. This is the problem. They consider Muslim personal law is the centerpiece of their identity. So while the majority community talks, with exceptions here and there, only in terms of uniformity, the minority community is obsessed with preservation and protection of Muslim personal law. Consequently, even sections of Islamic orthodoxy in India who are aware of glaring defects and shortcomings of some of the features of existing Muslim personal law, which is at variance on number of points with Quran and Sunnah, they are not willing to accept any reform. And therefore the resistance for reform, which was not there in the Muslim countries. That's why reforms there and not reforms here. These people are not willing to even go back to Quran. Because at the moment the demand is Islamize your law. Have a procedure of divorce which is given in the Quran. The Orthodox are not willing to accept even that. The real issue is therefore about the culture choice. The realization of social justice and rights to equality and other rights in family life cannot be culture free. Economic justice can easily be culture free. But justice in marriage and family will seek manifestation in differing, even divergent molds and forms as wide as cousin marriage and nieces being prohibited in one culture and receiving matrimonial preferences of brothers and uncles in another culture. But cultural autonomy and variations resulting from freedom of choice cannot justify some Muslim practices outside Muslim law and some legal provisions wherein mischief and possibilities of exploitations are inherent. As to the Constituent Assembly, what really happened, as I told you, that M.R. Masani raised this issue for the first time on 28 March 1947, include Uniform Civil Code in fundamental right. Had it been included in fundamental right, it would have become justiciable. It would have been the duty of the state to enact a Uniform Civil Code. If it does not enact a Uniform Civil Code, any citizen can go to the court of law. And Supreme Court would have directed that make Uniform Civil Code. So the initial idea was to have it in fundamental right. It was discussed and voted out. No. Then after 2 days, after a lot of advocacy by Rajkumari Amrit Kaur, Masani and Munshi, K.M. Munshi, it was said, okay, make it non-justiciable. It will not be implemented. Just for decoration's sake, keep it. So it became directive principle. Then there was again an effort by Rajkumari Amrit Kaur to bring it back from directive principle to fundamental rights, which again was not accepted. And finally the debate ended when Ambedkar, while winding up the debate, made this statement, which I am reading. All that state is claiming in this matter is a power to legislate. Even though Ambedkar was one of India's greatest lawyers, and I am nothing, I am too small a person, you know. He's most knowledgeable of all Indian freedom fighters. I consider Ambedkar to be most enlightened and most knowledgeable. But I am surprised at this statement, power to legislate. You need not include anything in directive principle to get power to legislate. You get it when it is there in 7th schedule. Since it was put in concurrent list, both government or state will have the power to legislate on personal law. But this is the reason which he has given very strangely. All that the state is claiming in this matter is a power to legislate. There is no obligation upon the state to do away with personal laws. Many of us think that fundamental rights are the negative restrictions on the power of the state. Because fundamental rights are negatively expressed. No one shall be deprived of his life or personal liberty, like this. and directive principles are the positive obligations. But look, Ambedkar, chairman of the drafting committee himself saying, there is no obligation upon the state to do away with personal laws. Therefore, no one need be apprehensive of the fact that if the state has the power, the state will immediately proceed to execute or enforce that power in a manner that may be found to be objectionable by the Muslims or by the Christians or any other community in India. Because the Muslim members in the Constituent Assembly, Mehboob Ali Beg Bahadur, Kokar Sahib and others, they said either write in the fundamental rights that freedom of religion will include right to follow personal law, or write in directive principles that this uniform civil code will not extend to people who have their own law. So Ambedkar is calming them down, that state is not going to proceed with uniform civil code without your consent, which Nehru subsequently and Indira and Rajiv all repeated. Sovereignty is always limited, which is also contradiction in terms, because sovereignty does not mean limited sovereignty. But this is how Ambedkar goes. Sovereignty is always limited, no matter, even if you assert it is unlimited, because sovereignty in the exercise of that power must reconcile itself to the sentiments of different communities. No government can exercise its powers in such manner as to provoke the Muslim community to rise in rebellion. This is the time partition has taken place. Muslims were in shock, but still they are saying in such a manner as to provoke the Muslim community to rise in rebellion. I think it would be a mad government if it did so, unquote. This, in my opinion, means a constitutional pact with minorities. Constitutional pacts are to be respected. Constitutional pacts are not to be violated. As is your constitutional pact with Kashmir under Article 370, that you join us with X, Y, Z exemptions. If we remove those exemptions, the law of contract says if there is a breach of contract, parties are to be restored to the original position. So it will automatically go out of Indian Union, technically speaking. Now that brings me to some of the arguments we make for Uniform Civil Code and how Guru Rankar responded to them. This is a 1972 interview. Interview goes like this. You don't think that a Uniform Civil Code is necessary for promoting feeling of nationalism? Arnab Goswami argument. This was a question put to Guruji. Answer, I don't. This might surprise you or many others, but this is my opinion. I must speak the truth as I see it. Next question. Don't you think that uniformity within the nation would promote national unity? Supreme Court in number of cases, Shah Banu and Sarla Mudgal and others talked in terms of national unity. Guruji, not necessarily. India has always had infinite variety, and yet for long stretches of time we were a very strong and united nation. For unity we need harmony, not uniformity. You need harmony. Don't destroy harmony in the name of uniformity. This is Guru Govalkar saying. And look what M.G. Vaidya is telling, that if you don't accept Uniform Civil Code, you lose your right to vote. Supreme Court said in number of judgments that the state is charged with duty of securing Uniform Civil Code for citizens. A beginning has to be made if the Constitution is to have any meaning. This is what Supreme Court has said. What did Guruji said to this? This is all right. This is all right. Not that I have any objection to a uniform civil code, but a thing does not become desirable just because it is in constitution. In any case, our constitution is a hodgepodge of some foreign constitutions. It has not been conceived and drafted in the light of Indian experience. And finally, to those, because number of TV channels said, oh, you have one criminal law, which is again mistaken. I counted the amendments to Code of Criminal Procedure. As many as 132 state amendments are there. So we don't have one criminal law, it is a mistake. Even punishments vary. There are states who have increased punishment for some offences, there are states which have decreased the punishments. In some states, for the same offence you can be arrested without warrant, in other states you will be arrested with warrant. All kinds of variations are there. So about uniform criminal law, Golwalkar said, there is a difference between the two. The civil law concerns mainly the individual and his family. The criminal law deals with law and order and thousand other things. It concerns not only the individual but also society at large. Now that brings me to how courts have reacted to Uniform Civil Code, and I said I have a problem with the courts. As a legal academic, I can afford to do it because I am not attributing any motive to any judge. It is an academic critique of how court has worded its judgment. No, their intentions are not doubted. It seems terms true Indian, un-Hindu or true Muslims surface routinely in these judicial decisions. Typically, the true Indian argument appears with respect to cases where religious law conflicts with other religions or with secular law. I give you an example. Shah Bano won the case, even though I don't consider Shah Bano case to be a Muslim law case. And I find all the scholars who have written on Shah Bano guilty of this mistake. It was a case under Code of Criminal Procedure. Code of Criminal Procedure says that a wife is entitled to maintenance. And the definition of wife given in the explanation to 125 says, we may disagree with this explanation because it is illogical. It says wife includes even a divorced wife. Now since it is a criminal law provision, it is applicable to everyone. It is not a question of Muslim law. It is not a question of personal law. When this law was drafted, this new explanation, the Muslim members in the parliament itself, they raised their voice, and then an exception was created in 127. Now 127 exception says that your duty to maintain your divorced wife will come to an end if she has been paid an amount due on divorce under customary law, or she has married, or she is living in adultery. These are the three exceptions. Now the question is meher that amount which is due to a Muslim divorcee on divorce? The earlier judgments by Tahira and Fazlanvi and others, they have said yes, meher is that amount, but the amount of meher must be reasonable. This is what Krishna here has said. Chandrachud rightly said in Shah Bano, but meher has nothing to do with divorce. Meher is a consideration for marriage. It is to be paid as a mark of respect by the husband at the time of marriage. Therefore, if you have paid meher, that does not absolve you of liability. Something else is to be paid. So the only question is, If the exemption of 127 is not available, the liability survives under 125. Where is Muslim law involved? But unnecessarily, and I have a huge grievance and a huge problem with judges on this count. They say, oh, maintenance is also provided in verse 241 of Surah Baqarah, chapter 2, cow. It says it is a duty on the righteous to make a reasonable provision for divorce. There was no need to go to Quran. Why should judges go to Quran or Dharma Shastras? We need not justify our modern progressive state law on the basis of any religious scripture. I may have highest respect for Quran as a book of God, but in interpreting CRPC, I need not go to Quran. I must stay within CRPC. One line judgment should have been, oh, benefit of 127 not applicable, liability under 125 is there, pay maintenance. Since you went to Quran, quoted translations, you fell in a trap of fundamentalists who said that the judges, Hindu judges, are interpreting Quran, Islam khatre mein hai, that kind of thing. You shouldn't do it. As in the temple entry cases, when in the first decade of Republic, laws entry into the temples, and this temple management challenged those laws, I think the simple answer should have been, well, untouchability has been abolished under Article 17. Article 15 says there cannot be discrimination on the basis of religion, race, caste, sex, place of birth. Thank you. But what did the court do? It went into the scriptures to say, well, untouchability is not an essential Hindu practice. Well, it is wrong, textually speaking, because you quoted some obscure text. To courts are nobody to determine what is essential, what is not essential. Courts should not become clergy. Let this job be done by clergy. Because this whole exercise of essentiality privileges one feature over another. As they said, having a beard is not an essential feature. Well, Muslims follow certain sources, so Quran is there, Sunnah is there. Now, sporting beard is made out from Bukhari, which is the most authentic book after Quran. So, religion will have, it is a package. There will be some things here, some things there, together they constitute religion. So, we should not say X is important, Y is not important. In Tandav dance case of Kolkata, where Anand Margis, wanted permission to dance in nudity with skulls and all, the court should have easily prohibited it in the name of public order. That is a state power. They said, well, in the Karya, which is their original text, Tandav dance is not mentioned. So if something is not mentioned in the religion, at the time of origin of religion, you will not permit it. That will mean you want to stop progress of religions. Then religions will become status quoist. There will be no reform. A religion evolves. So maybe there were things which were not there originally, but subsequently they adopted. As in the yesterday judgment, if you did not have beard in 2002, you cannot have in 2015 or 16. This is absurd logic. I was a sinner when I entered the service. Subsequently, I thought, "Amna marne wala hu, let me become religious." You say, now you can't become religious. In earlier cases of untouchability and others, they said we will decide the essentiality as per the religious scriptures of the concerned religion. We will see what is there. In the beard case, the original case was from Kerala about a police officer. They did not look at Bukhari. They said, oh, so many Muslims don't sport beard. So you adopted an empirical test. You did not go to the scriptures. That's why Supreme Court has been absolutely, consistently inconsistent on the question of essentiality. We need not take this path at all. We have enough police powers, state powers of reforms which we should use. So my difficulty with these cases is this, that in Shahbanu, after this lady has won the case, Muslim fundamentalists raised so much of hue and cry that poor Shahbanu apologized for going to the court. And poor Shahbanu, she had to say, no, I don't want this maintenance. Mujhe Allah miya kya bhi jana hai, dozakh na mile mujhe. And what did then fundamentalists say? She is a true Muslim woman. I have a problem with this true Indian, true Muslim, true Hindu. I have a problem with this terminology. The true Indian argument have been made in cases involving Hindu men who challenge the exclusive right of Muslim men to have more than one wife. For example, in Sarla Mudgal, there were 4 women who sued for bigamy their husbands who had converted to Islam in order to marry again without first divorcing them. Very strange things happen in law. Change of religion automatically dissolves marriage. So there was no need to divorce, by the way. But the Supreme Court held that second marriages violated Hindu personal law and were therefore invalid. And in the concurring judgment, one justice further noted that conversions were made only to escape the consequence of bigamy, having more than one wife. But rather than squarely condemning the defendants for their conversions to Islam, the court unambiguously laid the blame for fraudulent conversions to Islam. Rather than blaming these people, thank you. Rather than blaming these Hindu men who married another wife, the judges blamed Islam on the plurality, they blamed plurality of personal laws in India, and the judgment called the government to enact a uniform civil code for people of all religions. The court noted that state reforms of Hindu, Buddhist, Jain and Christian personal laws showed that these groups had forsaken their sentiments for the cause of national unity, quote unquote. That these people, Hindus and Jains and Sikhs, you know, Sikhs are very annoyed on their inclusion within the definition of Hindu. Even Prakash Singh Badal used to burn the copies of Article 25. He has also been convicted on that. And now BJP has a government with them for many years. Jains, they say we are a different minority. Yet they have been included within the definition of Hindus. But Supreme Court says that Jains and Buddhists and this and that had forsaken their sentiment for the cause of national unity, while other communities had not done so. The court implicitly distinguished between true Indians and those who engage in religious practices which deviated from rituals of the majority. So true Indians are those whose laws have been reformed. And I told you that they have not been willingly reformed. There was quite a resistance. Those who prefer to remain in India, this is how the court says, those who prefer to remain in India after the partition of India fully knew that the Indian leaders did not believe in two-nation or three-nation theory, and that in the Indian Republic there was to be only one nation, the Indian nation, and no community could claim to remain a separate entity on the basis of religion. I have a difficulty. If at all there was a choice for a group of citizens to remain in India, it was not a choice of Hindus, it was a choice of Muslims. They preferred voluntarily to stay here. Majority of them, massive majority of them. Sarla Mudgal decision, what did it do? It provoked communal animosity in two ways. First, by suggesting that bigamy is un-Indian. But that is rewriting history. Indians have always been bigamous. In fact, there are authors who say that this adoption of law against bigamy is a European influence. I have written in one article that in the United States now they are saying that we should permit restricted polygamy to some extent, and there are people who have predicted by 2040 America may permit some amount of restricted polygamy. So they are saying anyone who indulges in bigamy is un-Indian, and therefore the court implied Muslims are un-Indian. Now that is not wrong. Second, whatever the merits or demerits of bigamy, Muslims interpreted the court's pronouncement not as a statement about the plight of women, but as a statement about the perceived problems which Muslims pose to national unity and social reform. In this light, minorities viewed the call for a uniform civil code as a threat to their constitutionally protected right to manage their own religious affairs. Article 26. I already told you that how Shahbanu judgment, rather than serving the cause of uniform civil code, damaged it. Now the question of this whole question of social harmony and integration, on which there was a debate, as I told you, in Constituent Assembly, and this is what the judges have been repeatedly saying. We already have uniform laws in matters other than family laws, by and large, such as marriage, divorce, maintenance, inheritance, adoption. If you leave them, you have largely uniform laws. The assumption, this is an important point I am making this evening, the assumption that uniformity produces harmony and integration itself is to be questioned. This assumption is wrong. Uniformity does not create any unity or any harmony. I am going to demonstrate. Don't we have one law for the majority community? Largely one law, of course, customs are also recognized. Is there integration within the Hindu community? Amongst all classes of Hindus, there is huge harmony. Every day 2 Dalits are killed. Every 3-4 hours 1 Dalit women is raped. You have senas in Bihar, upper caste senas, lower caste senas. People in Karnataka and Tamil Nadu are fighting on Kaveri water. Shiv Sena, which has asked Modi government to come up with uniform civil code, and MNS, their cousin brother, they have been creating all kinds of disharmony amongst Biharis and UP Walas and Maharashtrians. So this uniformity of law, dissent will always be there between groups. Such dissent does not disappear by the presence of common law, one law, uniform law. One does not necessarily subscribe to the two-nation theory or multiple nation theory by insisting upon the preservation of the status quo of personal law. Within one nation, there can exist number of legal systems. In fact, federal government is all about this, that you will have one national government and you will have 25 regional governments. The idea of federalism is not an idea of uniformity. Then you should have a unitary form of government. Federalism is all about diversity and preservation of diversity. Those who oppose changes in personal law, in my opinion, are not necessarily anti-national. Though we may call them status quoist, we may call them conservative, We may call them orthodox. Let us not therefore condemn All India Muslim Personal Law Board or Jamiatul Ulama Hind or our local hero Asad Owaisi as anti-national just because they see some merit in the existing Muslim personal law, which many liberals like us think is regressive and dated. But just because they want to continue with this or preserve that law, they don't become anti-national. As I told you, that the Hindu Law Committee headed by B.N. Rao, there were people who made similar arguments. We never said they are anti-national. Democracy admits dissents. And since our is a plural society, any effort to regiment various ethnic and linguistic groups into a uniform mold could be counterproductive. Identity must be distinguished from separatism. There is hell of a difference between identity and separatism. Having distinct identities is not against national integration, and they do not necessarily lead to separatism. Different ethnic, religious and linguistic groups have different traditions and cultures, and they are entitled to preserve them. Personal laws are based on such variety of traditions and cultures, and therefore they cannot be obliterated just for the sake of uniformity. As and when Uniform Civil Code is introduced, I said I will quote another British, in fact Derek is no more, so he is the greatest Hindu law writer, Werner Mensky. As and when Uniform Civil Code is introduced, in Mensky's view, there is a strong possibility of a period of deep social unrest taking place. Unless the government is prepared to ride out this period. If it then gives in to those who don't want Uniform Civil Code, more damage will be done by introducing than by withholding Uniform Civil Code. Let us not have a repeat of demonetization pain for the so-called sake of uniformity. Let us not commit the mistake of having a uniform civil code, I am quoting Werner Mensky, even if bloodshed follows. This is not a good deal. If uniform civil code may lead to such kind of violence, an anti-majority, an anti-government protest, it is better to wait. The elite of India's legal thinkers should realize its remoteness from the masses and is currently undergoing a crisis of self-assessment. On the one hand, there is still the urge to press on with the idea of Uniform Civil Code, but on the other, evidence is it has not worked so far and does not work elsewhere. For if few enlightened individuals, like the one sitting here, do manage to separate law and religion, the average Indian may not. For him, law and religion is one. Therefore, they are not able to distinguish between Sharia and personal law. I have been saying that Sharia is closer to divinity. Personal law is fiqh. Personal law is based on human speculations. Personal law is largely human. But they are not able to make this distinction between fiqh and Sharia. And therefore they consider personal law as sacred. It may be easy for me to make this distinction, but it is not easy for ordinary people. It seems too simple to accept the argument that communalism is so strong in India because different communities do not have the same law. Rather, apart from competition for scarce resources and politicking of community leaders, the state itself has significantly contributed to communal tensions. It is not because of the diversity in personal law that you have communal rights. It is because of the state, many a times. So you don't have communal law rights because state is respecting diversity. You are having communal rights because state threatens that it will not respect diversity. And therefore we must ensure that we don't have communal rights for the sake of uniformity. Would modern India benefit from legal uniformity at all, or is it in fact counterproductive for the political unity of such a diverse and vast nation to press for uniformity in each and every respect? Is the personal law system really as wrong and divisive as is made out in media debates? It is far too simplistic to argue that personal law system perpetuating differential statuses creates only barriers and injustices. 2 days ago, there was an article in Wire by Abu Saleh Sharif and Khalid where these people had quoted 4 people who were running the Sharia court in Hyderabad. And similar statistics I got from Karnataka last week. Now these people who are dealing with divorces, they said 1 out of 160 divorces, as many as 130 were khula. It is a female who is asking divorce. Yesterday also there was a news that in terms of number of young Muslim girls, they out of choice are not marrying anymore. They are making a choice when they want to get into marriage. So some education has come to Muslim community also, to Muslim females also, who are asserting their right. So in Hyderabad itself, in the Darul Qaza courts, out of 160 divorces in last 4 years or so, as many as 130 were female initiated. She wanted to go out. Even in this Bharatiya BMMA study, as many as 40% divorces were asked by the women. And as many as 71% of divorces were not unilateral. They happened with panchayat, with NGO, within family, with Sharia courts. Even Zakia Soman runs Sharia courts. Even Zakia Soman is against uniform civil code. So there may be within personal laws also some silver linings. I give you one example. Last 6 months, Indian Supreme Court, at least in 2 decisions, went against the text of law and used the power of Article 142, which means the court in doing complete justice can pass any law. Even though the judicial precedent is, if there is a law, there is a statute, 142 power is not to be used. These were 2 couples in 2 different cases. They wanted divorce. Now under the Hindu law, you cannot have a divorce straight away. So you have to undergo a period of separation and a period of waiting, and divorce is difficult. The court said that this marriage has collapsed. There is no point in continuing with this marriage. And therefore they invoke their extraordinary jurisdiction, which they are not supposed to invoke since there was a law, Hindu Marriage Act, yet they invoked it. And they permitted divorce straight away. This entire period of separation they curtailed. So if marriage has collapsed, continuing in that relationship for the sake of marriage is now a dated idea. Today people don't have time. If marriage has collapsed, it has collapsed. Move forward. Therefore divorce procedure should not be very, very difficult, as it should not be very easy. Now, that brings me to another very important question which has not come in this debate. I'll take another 5-7 minutes to close. One is legal pluralism, I have already talked about. Now the other thing which I want to say is, many of us think state should have monopoly of lawmaking. But liberal scholars openly embrace markets and reject all government. Legal pluralism and radical libertarianism are well recognized scholarly traditions. And there is a consensus that the state is not the only source of law. There have been societies where the state was not making law. Even in Islam, as I told you, the state does not have lawmaking power. Lawmaking power is with jurists. Under Roman law, the lawmaking power was with jurists. Since Arabs were having trade with Romans, therefore there was an influence of Roman law on them. What is happening in the world? We must appreciate that people are going out of the state's civil adjudicatory system. Because this system is slow at their best and conduits for gross injustice at their worst. A recent survey of United States about 1,000 largest US corporations. Arbitration. Arbitration means what? You are not using a state civil system. So there is already privatization of adjudication which is taking place. People are not going to a state legal system. My worry is that too much of talk of reforms in personal law will revive, energize and strengthen Sharia courts. Supreme Court has already said that Sharia courts are not unconstitutional because they are nothing more than arbitration councils. So people will go to that system. If they go to that system, you cannot compulsorily bring them to a state system. So it will be a regressive step. In UK also, already they are saying that the death of civil justice system is taking place. Mediation is emerging as a new norm. Because in the adversarial system which we follow, one party wins, another party goes frustrated. In mediation, no one wins. So both the parties go satisfied. The cost is less. It takes less time. It is speedier. So what kind of uniform civil code we are talking about when civil justice system as such is on decline? Now, lastly, I just want to say something about the Muslim personal law. As I said, that this is not Islamic law. It was said Anglo-Mohammedan law. There was quite a British influence on it. When British came to India, they continued with the Mughals' policy of not interfering with the indigenous people's law. So Hindu law was applied on Hindus, they called them Gentus, and Muslim law was applied on Muslims. And if there was a dispute between Hindu and Muslim, the law of the defendant was applied. Then in 1726, when letters and patent was issued during the reign of King George I, it enabled the court to decide according to justice and right. So this was the beginning of the incorporation of English common law into Indian law. Because this justice and right eventually became equity, justice and good conscience. As a result, British judges damaged both Hindu law as well as Muslim law. First I will give the example of Hindu law. You see, when we reformed Hindu law in 50s, we were so much against Hindu law. We thought everything in Hindu law is bad, as we are thinking everything in Muslim law today is bad. Everything in Hindu law was not bad. The British judges, because in England at that time, female was not a complete owner of property. So British judges could not understand that under the Stridhan concept of India, a female can be an owner of the property. And therefore they damaged our law and created the concept of life estate, that she will use this property during her life and then it will revert back to male lineal descendants. Similarly, for Muslim law, the British judges could not understand that Muslim law does not follow the doctrine of precedent. Precedent means that the previous decision is to be followed. Now Islam has that flexibility. Each case is to be differently decided. So what was decided in Shahabano in a case of divorce may not be decided on similar lines in another case. English doctrine of precedent brings in certainty in law. It brings in predictability in law, because you know if this is the circumstance, last decision was this decision will be like that. But it also brings in rigidity in law. And therefore on the continent of Europe, those who follow civil law, they don't follow the precedent. So previous judgments are not followed. This insistence on previous judgment made Muslim law rigid. The other problem of the British was that initially they took the help of Pandits and Maulvis to advise them on Muslim law and on Hindu law. Then subsequently, because you have all the schools, both under the Hindu law as well as Muslim law, so on the same issue contradictory advice was given. One ulama said one thing, another Pandit said another thing. So they said, oh, we should take it over. Therefore they ordered translation of Dharma Shastras and the books of law. And remember, they did not order translation of Quran. They ordered translation of Hidayah. Because Muslims predominantly in India are Hanafis, and therefore their book of law is Hidayah. It is not Quran. That's why all the time on triple divorce, going to Quran may not be a very appropriate thing. Because Quran is not like an act. It is not like this constitution that I can read Article 21 is law and Article 25 is law. No. Within this also I have told you, fundamental rights are more this mandatory national anthem singing controversy. Now this order of Justice Deepak Mishra and Justice Amitabh Roy, both very learned judges, is not law under Article 13. We cannot challenge this in a court of law that it violates my freedom of religion. But it is law under Article 141, because law declared by Supreme Court shall be binding on all courts. For that purposes it is law. Similarly, Muslim personal law, when there is a dispute between two Muslims, is law, but it is not law under Article 13, and anything which is not law under Article 13 cannot be challenged on the ground of being violative of fundamental rights, as constitutional amendment is not law. So we amend the constitution, but we cannot challenge a constitutional amendment on the basis of fundamental rights. The limited window is whether that amendment violates basic structure. Very limited. And the burden is very high. The other thing which I want to say is it is wrong to believe that there have been no reforms in Muslim law, and it is absolutely static. The 1939 Resolution of Muslim Marriage Act was a very progressive step. And this is what I want to impress upon ulama, that they need to be progressive and enlightened. The problem in 1939 was that ulama borrowed from different schools and it became a law. Therefore today again it is possible. Why I am again and again insisting on taking ulama on board? Because the question of religious law is not to be settled just by a judgment of the court. In 2002 already Supreme Court has said, a number of half a dozen Indian high courts have said triple divorce is not valid. Still in 2016 we are debating triple divorce. So mere judgment will not help. Unless ulama come on board and they also agree with the judgment. And that's why I am saying that ulama should at least come forward to say that the only form in which a divorce will be given will be the Quranic procedure, where there will be first efforts of reconciliation, and then there will be mediation, and then just one pronouncement and waiting of 3 months, so that once passions cool down, there is a time to resume and repair that relationship. The question of divorce, we are all talking banning. As a student of criminal law, I am worried. What are we talking? Banning means making it criminal. everything which is bad do we ban? Killing of a human being, intentional killing of a human being is a homicide, punishable under 302. When did Supreme Court said killing a human being is unconstitutional? You need not do that. Banning in any case is a legislative act. Say we had made a law banning beef, so Maharashtra had to amend their animal slaughter law. Haryana had to amend their animal slaughter law. You need a legislative action. Matter is in Supreme Court and we want Supreme Court should ban triple divorce. It cannot ban because that power is not there with the Supreme Court. That power is with the Parliament. If you want a ban, you need to go to Parliament. And finally, as I conclude, my basic conclusions, or before I go, that we think that there is a diversity of law in the country, just before I conclude, because of religions. This is a mistaken idea. It is a myth. In India, we have different laws, not because I am a Muslim and you are a Hindu and X is a Christian and Y is a Parsi. Where do we live? It is a question of territoriality. If you are living in Andhra, you follow different law. People in Andhra and Telangana don't follow the Sapinda relationship which we follow in the Hindu Marriage Act. Here, a niece can marry the real maternal uncle. So, this is wrong. I think we don't have a uniform law. Just to give one example, the reformed Hindu law of 55-56 is still not applicable in Goa. The Special Marriage Act has not yet been extended to Goa. The Muslims in Goa are not governed by the Shariat Act. They are governed by the Hindu law. So you have Muslims in India who continue to follow Hindu law, unreformed Hindu law, Shastric Hindu law. Even in Jammu Kashmir, local Hindu statutes do differ with the central enactments. So all over in Pondicherry we continue to have French law. So you have too much of diversity in the entire country. So how do we really do justice within Muslim personal law? And that brings me to my conclusion. I believe that there can be an Islamic solution. There can be a solution without any communalism, without any passions being raised and bloodshed, as Werner Minsky talked about. We need not do even ijtihad because ulama are not very keen. Sherwani Sahib is worried, why did they close the door of ijtihad? So let us now consider Islamic solution of polygamy and divorce, and divorcees' right, including right to share in property acquired during marriage. All such remedies and many more, in my opinion, can be sought in the framework of standard performa as nikahnama, matrimonial deed, providing for stipulations on these accounts, prohibiting the husband from taking a second wife or constraining him to make it subject to her consent, spelling out terms of fair and kind treatment if so desired, and laying down terms of divorce and making husband commit to the ihsan form in 3 months with the provision of machinery for reconciliation and detailed working out of terms of divorce, including matan bil maroof, that maintenance, a reasonable and fair provision, and finally the provision of delegated divorce, where wife can also divorce. Ideally, most divorces should happen through mutual consent, and this will not require ijtihad because Muslim marriage is a contract. Even Maulana Ashraf Ali Thanvi has made such a contract. Even Allama Iqbal in 1930 has favored such a contract, and therefore I believe that that is the solution which will not be opposed. As far as Uniform Civil Code is concerned, to conclude, I may yet again say that there is scope for not only contemplating but fully accepting legal pluralism rather than uniformity. Should not India be proud of her immense diversity in every possible way and take this as an asset rather than something that needs to be legislated away. In the context of modern Indian law, how useful are the diverse legal concepts found across the world? Is their perception of state law and various kinds and levels of non-state law right? Is it correct to assume that Indian criminal law operates and is applied in uniform way? If we have so much evidence that the various steps towards unification have been so painful and unsure that the technique of gradually codifying all personal laws separately will also not work, since it does not necessarily lead to absolute uniformity, why do we remain wedded to the idea of uniform civil code? My 5 conclusions today are: I am for UCC, but not in one go. I do favor piecemeal reforms over a period of time, which has happened. Domestic Violence Act is applicable, 1939 Act, number of other laws, marriage registration laws. So I favor piecemeal reforms over a period of time so that lofty goal of gender justice is achieved without polarizing or communalizing our society. Small doses of reform in a series of legislations would be a better option and would not permit fundamentalists on either side to hijack the debate. Uniform civil code debate strengthens the majoritarian chauvinism on the one hand and minority fundamentalism on the other. In fact, uniform civil code, like the cause of Hindi as a national language, has suffered due to the over-enthusiastic espousal by its crusaders. I do see merit in legal pluralism for extremely diverse Indian society and do not consider uniformity in itself as a laudable goal, and do not believe that a state should have monopoly in lawmaking. I don't consider that if you don't have uniformity, you will not have national integration. In my opinion, uniform civil code is more of politics and less of gender justice. I deny centrality of law in achieving social change. Hindu law has been reformed, particularly the daughter's share in property. In most cases, people will away their property to sons. There is no property left for daughters to get. There have been surveys done in Andhra Pradesh and Orissa and Bihar that they are getting about 1/20th of what they are entitled to get. So mere normative changes in law will not bring about any gender justice. One possible mechanism for gender justice within family, in my opinion, which has not so far been explored, is the insurance cover of marriage, which can be taken recourse to by all, irrespective of religion. And I do consider that reforms within Muslim personal law are desirable, and ulama must come forward. If they don't come forward, the entire law will go. Thank you very much.
What a way to end 2016, ladies and gentlemen. A talk that went on for an hour and 47 minutes, uninterrupted, undisturbed, and not with anyone getting up and walking out. Phenomenal. Thank you so very much, Professor Mustafa. Thank you so very much indeed. This was a wonderful way of ending 2016 for Manthan. May I request Mr. Shehbani to please offer a small memento to Professor Mustafa before we open up this for a dialogue with you all.
Is it brought?
Keep coming, sir. Keep coming. Okay.
This is a comment, more a comment than a question. I'm Nagendra, a practicing advocate of High Court. I must thank you for giving a wonderful, scintillating lecture on a very interesting and controversial topic. and the topic, the way that it is dealt with, is constitutionally valid, rational, logical, and consistent with the constitutional principles. And I really thank you for giving the opportunity to the Manthanites to open up their vistas and the vision, particularly in the context that the authoritarianism is now is trying to topple the constitutional framework in this country. And in that context, the debate organized by Manthan is laudable, and they chose the right person for the right topic. Thank you.
We'll come back to you. Give it to them. Okay.
Sir, is triple talaq according to you constitutionally valid or not?
I said it, that the question of constitutionality will arise if triple divorce is law within Article 13. And in my opinion, it is not law within Article 13. It is an opinion of jurists. Now, the Allahabad case, just last week, all newspapers covered it, TV channels covered it, but the facts did not come to the fore. Two cases were there, two separate cases were there. In one case, the husband has married another woman, and this second wife has gone to the court saying that the mother of the first wife is threatening me that I will get police, and police is also trying to threaten me, and therefore protect me. The second wife going against the mother of the first wife. And of course the question was whether the divorce which he has given is valid. But a Muslim need not divorce his first wife to marry second wife. And therefore I believe the question was wrongly framed. Of course the judge did not decide it. So the judge has not made any judgment. A judgment, as you know, lawyers are here, is the determination of rights and liability. The judge said, oh, matter is pending in the Supreme Court, I need not say anything. Therefore I believe all these observations were unnecessary. The other case is more interesting. Here the husband was living in Dubai and the wife was living in India, and wife developed some relationship with some man of her choice, which is possible. Now she married this person. Now the husband returned immediately from Dubai. Wife said, well, my marriage is dissolved, who are you? You gave me divorce on telephone. And triple divorce is valid. Triple divorce irrevocably dissolves marriage, therefore get lost. And the poor husband was saying, no, I did not give any divorce, you are lying. Is it so? So in both the cases, very strange facts were there. What Supreme Court has already done in Shamim Ara and in several other cases, Delhi High Court, Maharashtra, Bombay High Court, Guwahati High Court and several others. They said when 3 divorces are given, they will be counted as one. 3 divorces will not dissolve. 3 instant divorces given without cause, without reconciliation, will be counted as one, and marriage will not dissolve. There is a question of unconstitutionality. The law has been laid down that 3 divorces will mean one. But for people who are not really appreciating the whole thing, triple divorce in itself is not going to solve the problem. Because if some husband is determined to give divorce, he will wait for 3 months. At the moment what we are asking, don't give instant divorce. Give it in 3 months, so that there is time for reconciliation. If some marriage has collapsed, there is no chance of repairing it. The eventuality will happen after 3 months. Therefore, what is more important is how rights and duties are determined. And therefore, whether you hold triple divorce as unconstitutional or not. In my opinion, it is not a case of holding it unconstitutional. What you said was right, that it will be counted as one. Is this have a nikah nama? How divorce will take place? Have talaq-e-tafweez, where wife can also give a divorce. As I told you, that latest data is showing that the problem is very small. One, the divorces itself in terms of percentage are less. If you compare the deserted and abandoned wives, then the rate is about 2.6 or 7 for lakhs for Muslims, and it is about 2 million for Hindus. Therefore, Prime Minister's interest in Muslim women, which is appreciable, but is misdirected, because you have to take care of separated and abandoned wives, which is 2 million, isn't so? So how do you settle the question after divorce? If divorce is khula, it is at the initiative of wife, then even triple divorce may be right. If triple divorce is as a result of mutual consent, then there is no problem. Only when it is unilateral, instant, then there is a problem.
I have a point to make. That reformed triple talaq that you talked of is probably a reform Hindus should be wanting in their law. No, I'm serious. One needs to have a much easier way of closing a marriage or dissolving a marriage. And this is a significantly easier than...
but not very easy.
Yeah, fair enough. That's why I said your reformed... Yeah.
Good evening. Good evening, sir. Myself Manthan, pursuing IPCC. What measures should we take to protect couples who enter into intercaste or interreligion marriages?
That is not the topic I was speaking, but they need to take the recourse of law. The law should protect them.
Yeah.
Yeah, very good evening. It was quite an enlightening session. Though I reached late, but 45 minutes I have been watching it live on my smartphone all through. And as very rightly pointed out by Professor Mustafa, that Muslim personal law is different and Sharia law is different. I'd like Professor Mustafa to elaborate more on that, because Sharia law is a divine law and Muslim personal law is it a man-made law. I just need clarification from Professor Mustafa. Thank you.
I said it that whatever is Muslim personal law in India, it includes acts made by the Parliament, by the British. So 39 Act, 37 Act. Now people have challenged the 1937 Sharia Act as unconstitutional. They say it provides for polygamy, it provides for triple divorce. I haven't found this word there. It is a small enactment which merely says in matters of marriage, divorce, adoption for Muslims, Muslim law will apply. It nowhere says that you have polygamy or you give triple divorce. It is not there. So this Muslim personal law which you have in India today, it is having number of judgments which are part of this. You have number of enactments which are part of this. Then there is uncodified law. Now the uncodified law for each school is different. So Hanafis follow Hanafi law, Shafis follow Shafi law. And that uncodified law, in my opinion, is not law under Article 13. But there is a variance between Muslim personal law and Sharia, because we need to make a distinction between Sharia and fiqh. Sharia will be, say, believe in oneness of God, angels of God, prophets of God, day of judgment, books of God, principles from which through jurists we extract law. That is my answer.
There.
It was an exceptional talk, Professor Mustafa. I feel that you should be a part of a Muslim personal law board.
They will be very, very unhappy with me, you know.
I understand, however, the kind of stance you have on the entire subject and the mastery of the subject is unbelievable. And the understanding of the laws, because in Muslim, it is always recommended that a person who is having the authority or the knowledge or the expertise should be a part of the entire decision making process. So I personally suggest, if we are not utilizing your caliber or the kind of expertise you have, I think it will be an irreplaceable loss to the community. That's my feeling.
I don't enter the debate, as a Muslim. I enter the debate as a student of law. Isn't so? And Muslim personal law is not my area of specialty. I am a constitutional law student. I had to enter the debate when I saw uninformed discussions are taking place. So this is not my specialty. I think that people who are there in personal law board, they are experts in Islamic law or Muslim law, and they know best how to defend. I am neither for Muslim personal law board nor for Muslim personal law per se, but I just wanted to bring some perspective to the debate. Therefore, I am saying it is not a question of mere freedom of religion under 25. It is also a question of group's right to manage its own matters and religion under 26. In my opinion, Muslim personal law is also a question of culture. Law is the producer of a culture. Law is also subject of the culture. Law grows in the society, as Savani has said, like the language. Therefore, there is quite a close relationship between culture and law. And right to culture is an absolute right. There is no restriction on this. Even in the name of public order, health and morality, you cannot curtail somebody's culture. No culture is bad. Isn't so? So every culture is good. So I consider that they are entitled to follow their culture, but within the cultural relativism, there is an angle. That a community is entitled to existence as a cultural community. But within the community, there may be minority. As Muslim women is a minority within the Muslim community. Now, in the name of your right to cultural autonomy, you cannot violate the right of Muslim women. Therefore, within that community, you have to protect their rights. Therefore, I am all for uniformity of rights, but not for uniformity of laws. There may not be one law, there may be different laws, but all laws must be just and they should give almost equal rights.
Absolutely. Done.
My question to you is, some of the people may think that it is you have been utilized to influence people for the reform. For the reform. So, some people see you as a person who is supporting the government in its initiative for this kind of purposes. After listening to you, nobody should say that. However, this is a perspective in the
whatever I had to write, I have written in black and white. So you can read it whether I am for government or not government.
So it's been an absolute pleasure and a privilege being here listening to you. There are two issues that are kind of bothering me that I'd like to get some clarity from you, which are live right now and happening. One is the national anthem issue where it is a dictum by the Supreme Court that one has to stand in a theater, and my question is why, and why only in the theater, number one. And the second is what I read today in the newspaper about in the Air Force, a person cannot have a beard. When, for the longest time, there have been Sardarjis, etc. Even the even the chief of the army sports a beard. Not this one, but in the past and maybe in the future. So I'd like to get your opinion.
I did make a mention in some detail that the whole problem is that on the question of freedom of religion, Supreme Court has unnecessarily invented a doctrine, what they call doctrine of essentiality, under which the court determines what features of your religion are essential, and only essential features of religion will be protected. Accordingly, they have said that having a beard is not an essential feature of Islam. That is why this problem. Now, my problem is, as I said in my talk, that they say if you had beard in 2002, you may continue. If you did not have it, you can't have it. But this is an evolutionary process. I was irreligious yesterday. Today I may become religious. Therefore, there has to be some room for that. In any case, if they want to have discipline, they should decide, uphold the dismissal as per service rules without going into the question whether it is obligatory or it is not obligatory, because it is disputed. That some consider it obligatory, others don't consider it obligatory. I give you an example about Sikhs, since you made a mention. There was a case in Punjab where in a minority Sikh medical college, everyone has to give there was a reservation for Sikhs. So everyone had to give an affidavit that my name is Kaur, my name is Singh, I believe in Guru Granth Sahib, and I believe in all the tenets, this and that, and I have never cut my hairs or indulged in plucking of eyebrows. Now thereafter someone noted, after admission and everything, that some girls have done this plucking of eyebrows. Of course it is special here. So their admission committee took seriously and their admissions were cancelled. And as a result the matter went to the High Court. And their High Court said that here is an essential feature of Sikh religion. Of course it is also disputed because it is there, Sardarji is here in the Rahat Maryada or something, it is there. So some people dispute it, whether it is essential or it is not essential, but ideally the court should not go in that. In America the law is assertion test. The assertion test means if someone comes to the court, he says, I believe in this this is my religious belief. The court will not enter into a debate, whether it is fundamental, not fundamental. You consider, Indian Supreme Court has also said that freedom of religion is individualistic. It is a relationship between individual and God. Whatever that individual consider as religious, we must concede. If we want to reform, then the powers of reform are there with the government in the name of public order, health, morality, other fundamental rights, social reform, economic reform, reform of secular activity associated with religion. Under all this we should reform. Why should we at all go to the religious question? As I said in Shahbano, there was no need to go to Quran, whether maintenance is there in Quran or not there, because it was a 125 case. On the national anthem thing, I have written on this, in Indian Express. The problem is that people who are going for entertainment, ideally they should not be given lessons in nationalism. And why only in cinemas? As per the Government of India Ministry of Home guidelines on national anthem, even in schools, national anthem is not mandatory. So why make it mandatory in the cinema halls? But my worry is that Justice Mishra has used word constitutional patriotism. Now this expression constitutional patriotism has a lot to do with German philosopher Habermas. Now Habermas talks of constitutional patriotism in the context of individual autonomy, individuals' rights, human rights. Therefore, constitutional patriotism does not mean patriotism. It means that there can be some fundamental principles on which one can agree. And because of constitutional patriotism, European Union could be formed. Isn't so? Now, this judgment goes against another judgment of Indian Supreme Court given by a judge from Hyderabad, Chinnappa Reddy, national anthem case. Because the law at the moment as it stands is, National Honours Act, that singing is not compulsory, standing is not compulsory. What is punishable is don't obstruct nationalism. If national anthem is sung, don't disturb it, don't shout, don't raise your voice. So in that case of Kerala where 3 Jehovah Witnesses students were there, they did not sing national anthem because their religion says they should not sing in praise of anyone except God and Son of God. They were suspended from or rusticated from the school. So Supreme Court said they stood respectfully, their eyes were shut, their heads were down, they did not obstruct, and therefore they were exercising their right of silence, which is implicit in freedom of speech, and therefore their rustication was wrong. They went back to school only one day, thereafter father withdrew them, and they were not educated. And the last line which Justice Chinnappa Reddy has written, I think I must quote it here, our traditions teach us tolerance. Our constitution preaches tolerance. Let us not dilute it.
I have a question here.
1 minute. Yeah.
Okay.
After this, I have to think when in my life of 84 years I have had a more enlightening, illuminating, जिसे कहते हैं दिमाग के चारों तबक रोशन हो गए, and remarkably free, frank and sincere expression. I congratulate and thank you, sir. On one point I have my differences with you. The All India Muslim Personal Law Board, in my humble opinion, is just a magnified, verified cup panchayat. And something will have to be done about it. The Shah-Bano case, as you have pointed out, was not under Muslim personal law. It was under section 125 or whatever of CRPC.
Right, please.
The Muhammad Ahmad Khan, Shah-Bano's husband. Muhammad Ahmad Khan, Shah-Bano's husband, was himself a prominent and successful lawyer. He should have realized this, and he should have contested this case in the lower court, not on Sharia, but on CRPC. Shah-Bano was not a destitute. She was not on the verge of becoming, what is the word there? And she had 17 bighas of land. She had a double-storied house. She had 2 sons working and earning. She was not a destitute on that point. But Muhammad Ahmad Khan tried to be a hero of Muslim personal law, of Islam, of Sharia. And he came to the All India Muslim Personal Law Board. The All India Muslim Personal Law Board should have told him that this is not a case under Sharia. You fight it under CRPC. Finished. But they took it up as a challenge against Islam and Muslim rights and etc. It is they who made it into a case of Muslim personal law. It is their lawyer who presented before the Supreme Court a copy of the translation of the Holy Quran by Maulana Yusuf Ali in which it was written that Mataun bil Maruf is maintenance. While in 7 other translations of the Quran into English, Mataun bil Maruf is only a parting gift. It is the lawyer of the All India Muslim Personal Law Board which bundled the case and made the Supreme Court give what you call a wrong judgment. And then, just in order to appease, please, just in order to obtain the votes of a community, the then government decided to overrule a decision of the Supreme Court, which I think was one of the most dangerous and detrimental steps to have been taken.
Yeah, absolutely.
If the Muslim Personal Law Board thinks that they can do it again, they are sadly mistaken, because the present government is nothing like Rajiv the then
Congress.
yes, Rajiv Gandhi's Rajiv Gandhi's government. It is, and that government needed Muslim votes. This government is not going to get any Muslim votes anyway. So it does not need Muslim votes. And if the Muslim Personal Law Board, it is still, I heard a statement there, read in the paper, they say, एक दफा सुप्रीम कोर्ट के फैसले को हम कलअदम करवा चुके हैं, दोबारा करवा देंगे. सुप्रीम कोर्ट होता कौन है फैसला देने वाला? These kind of statements coming from, you see, what are we Muslims to depend upon? Who will save us if not the courts? In a majority country, a minority with a hostile attitude towards the majority. If we are going to undermine the judiciary and the Supreme Court, we will be digging our own grave. Sometimes the judges do make blunders and mistakes, as you have pointed out, but I think as a community, our safety lies in upholding the judicial system and the constitution and the laws of our land. Similarly, in the Babri Masjid case, it was not a case of the Sharia. It was a case that there has been a mosque for 500 years. There would be record, there would be khasra, katoni, patwari, there would be municipal record, bijli ke bill, pani ka bill, municipal taxes, the appointment by the Waqf board, appointment of the mullah, salary of the muazzin. All these records should have been presented. They didn't. They insisted upon. Quran says that when there is a mosque, it cannot be shifted. In Saudi Arabia, 10 mosques have been shifted. Just like this day, a bulldozer comes and shifts the mosque. But in India, as you say, things can happen in Muslim majority countries, but not in a Muslim minority country. Now, this kind of thing, it is the All India Muslim Personal Law Board which bundled the Babri Masjid case, and it made the courts give the most, I mean, I'm sorry to use the word, idiotic judgment that this belongs 1/3 to Hindus and 1/3 to Muslims and 1/3 to someone else. Now this kind of a judgment you don't, but when you bring in the Sharia and on the other side they bring in Hindu mythology and then they say 9 lakh saal pehle yahan Ramchandra ji paida hue the, and the All India Muslim Personal Law Board says जहाँ मस्जिद होती है वहाँ जमीन से लेकर आसमान तक मस्जिद होती है. My God, जहाँ मस्जिद होती है वहाँ यहाँ से लेकर जहाँ तक खोजा जाए मंदिर होती है तो मस्जिद होती है. And then saying, अगर किसी ने ये साबित कर दिया कि यहाँ कभी मंदिर था तो हम खुशी खुशी बाबरी मस्जिद को हिंदुओं के हवाले कर देंगे. उनका बहुत अच्छा तो खुदाई शुरू कीजिए तो लिहाजा खुदाई शुरू हो गई. Now this and who are these ulama? Ulama. Who is an ulama? Does ulama mean just someone with a beard? Are you not an alim? Is Tahir Mahmood not an alim? Justice Hidayatullah, Chief Justice of India's Supreme Court and one of the finest judges my country has known, he said that Muslim law needs reform. Justice Hamidullah Beg, another Chief Justice of the Supreme Court, said that Muslim, are they not ulama? Is A. Faizi not ulama? Is Asghar Ali Engineer not ulama? Is, I mean, so many others are. And even I not better than many and ulama. I'm sorry. I'm sorry. After this really remarkable, I mean, amazing evening, I am absolutely delighted. I wish you all the best. I wish you long life, best of health, happiness, success, and I wish that, as someone pointed out, that you will replace the All Indian Muslim Personal Law.
I think we should come to a close.
It's off. I have a question.
Okay, Vikram.
I just
Okay,
you don't want my response? I'm grateful to you for all the kind
words. It's all a perception thing, you know. Neither me or Hamidullah Beg or Hidayatullah will be accepted by Muslim masses as someone who can authoritatively tell them what is religious, what is not religious. So I need to accept our limitations. Now, Personal Law Board, after all, is one NGO. Isn't it? So, over the years, somewhat this impression has been created that they are the sole representative of Muslim masses. You know that there have been several other personal law boards, the Shia Personal Law Board, then Muslim Women Personal Law Board, and then some other personal law board. The precise point which as to Shabano I was making, that whatever lawyers may argue, ultimately the judgment is written by the judge, and therefore the judge should not pay attention to irrelevant arguments. I believe this entire, had he not referred to Quran or said anything about personal law, it would have served the cause of Muslim women better.